we're here on a summary judgment motion, quiet title, permanent injunction. It relates to two easements with the same neighbors, extending, one extends onto both of their properties. One is solely on the Richardson property, at least the portion that is in controversy. I thought I would run through the survey documents. If the court has those handy, great. If not, that's all right too.
I reviewed them before coming on the docket, but I'm happy to turn to them if you tell me where I can find them.
All right. So starting with the Dan Renton declaration, page 33. The pages might not be numbered, but when I look at it as a one whole PDF, it's a 33-page document. Or sorry, it's page 33 of the overall document. Let me know if you're.
Can you give me the one more? Which declaration am I looking in?
Daniel Renton.
Yeah,
The
I
auditor's
have that. Thank you.
Auditor's file number ends in 831.
There it is. I was looking at a supplemental declaration by Dan Renton that definitely did not have that many page numbers. But go ahead, counsel.
Yeah.
I got it now.
Yeah, the first one. Okay. This one is dated May 1st, 2001. It's the earliest of the relevant surveys. Note how this is prepared by Kevin Bloom. It shows the properties in pre-boundary adjustment configuration. So in just a minute, we'll see the language on the next survey is the boundary adjustment survey. So we're looking here at pre-boundary adjustment survey. This is when the property was under common ownership. So Chilton Inc. Was the owner of these parcels. Later on, they boundary adjusted and sold. But here we can see they contemplated that there would be an easement through here. And again, common ownership. Going one page later in the Renton declaration, we see the boundary adjustment survey. This is the one, the auditor's file number ending in 828. And this is the one that we'll probably reference more through this hearing. And again, we see that same 60-foot easement. We also see the 40-foot easement. And we see parcel numbers here, 1, 2, 3. And again, there's still common ownership. We see that this is labeled a boundary line adjustment, again, by Kevin Bloom. And this was only less than a month later. The first one was May 1st, and then we see May 22nd. So just a short while later, Chilton was obviously working on this during that time. And we see in clear print, 60-foot easement. We see an easement depicted. We see a line table giving bearings. And we see some dimensions there over lot 2. Lot 2, of course, being what's today the defendant's property, lot 1, plaintiff's property. And I'm going to set that where I can see it because I'm going to be referencing that one in no time. Going forward to the 2005 survey, and this one won't be all that long. This is another Kevin Bloom survey. It's just for a different property, plain and simple. Maybe it's in the neighborhood, but it's the opposing party would fault Mr. Bloom for not surveying easements over a property he wasn't surveying.
I'm sorry, counsel. I'm having a hard time catching up to which page you're looking at.
Let's see. This would be supplement declaration of Dan Renton's pages aren't all nicely marked. Let me tell you.
I'm trying to, I think I had the first one right. I'm not sure if I'm looking at what you're wanting me to look at or not on the second one.
You bet. The following page 36 of 44 of Renton Declaration number 1. Right. So just a moment ago, we were looking at page 35. And so if you flip one page to 36.
Give me a second, because I don't have page. I'm looking at a hard copy, so I gotta log on and look at the
Understood.
PDF to make sure I'm looking at the correct page. And this is the Renton. I want to make, because I'm switching between the hard copy and the electronic copy. So we're talking about the declaration dated March 13, and it's You said it's page
Uh,
35 and 36, correct?
Now, I mean, perhaps it was filed the 13th, but it's signed March 6th.
Okay.
And then, yeah, so go down to page 36. We were just a moment ago, we were looking at page 35. So page 36 should be an auditor's file number ending in 728.
Yeah, okay, I've got that online.
Yep. So we can see the subject of survey ending in 728 is this property well to the eastern end of the area depicted. Our properties that we're arguing about are well to the west of this. They don't even purport to be surveyed. Um, and what I'm getting at is this survey is just irrelevant to our current dispute. The fact that there are not easements depicted is of no difference when that wasn't what was being surveyed.
Okay.
Yep, that's all for that one. The next survey we see was attached to the Richardson declaration. It's dated March 2024, Bates number 134. I guess this would be supplemental. Supplemental declaration. Exhibit 1. If you're going by pages of the PDF, it's page 3 of 32.
This is the supplemental declaration of Dan Renton or someone else?
No, Miss Richardson herself, the defendant.
Okay,
It's exhibit 1. So she intends to use this survey to say, hey, there's no 60-foot easement shown over my property. Do you
okay,
have that in front of you, okay?
okay,
Now, I know these print out in really small print because it's a big size image condensed down, but on the middle right of the page, we can see easement note. And in there, you can see Mr. Brown saying, I wasn't hired for easements.
okay,
Okay. And so that March 2024 survey right here is irrelevant to easements.
okay,
Okay. So I'm gonna, like I mentioned, I'll be going back and referencing um, the Renton page 35 survey, the May 22nd, 2001. And so it's helpful for me to have that in front of me for this hearing so I can look at it.
okay,
And then we recall that all these properties, there's 3 of them, they were owned by Chilton Inc. back in 2001. And so Chilton Inc. sells after their boundary line adjustment. And then we see that boundary line adjustment survey again, 2001. In July of 2001, they sell the first of the 2 relevant parcels. I'm not concerned about the third. And they describe it per this 2001 survey. They say track 2 of survey. They give the auditor's file number. I'm looking at exhibit D to the declaration, the first declaration of David Ori. I apologize for all the jumping around. I realize there's a lot of that.
okay,
Okay, so we see a legal description that simply reads track 2 of survey recorded in volume such and such, auditor's file number ending in 828. That's
So
the
I'm trying
exact.
to track where you are, but I'm having a hard time. So
Okay,
what are you looking at right at the moment?
you bet. So the first filed declaration
Yep,
of David Ori, and so let's see, that would have been filed. Do you have that in front of you?
I have that in front of me. What specific
Okay,
exhibit within that am I looking at?
D, exhibit D,
Okay,
exhibit D. So this is a 2001 deed that was recorded shortly after that 2001 survey.
okay,
It references 2001 survey by auditor's file number. So we know we're looking at the correct survey. It says, I'm conveying out track 2 of that survey. It says, together with an easement for ingress, egress, and utilities. And then below that, it says, subject to covenants, conditions, restrictions, reservation, easements, and agreements of record.
Okay.
Now, noteworthy is the language it uses to describe the easements it's giving these properties. Now, this particular deed conveys defendant's property, so we're less concerned about easements conveyed to the defendant's property, but this language is consistent throughout, all right? So it references old auditor's file numbers. So see in that paragraph ending with 2 numbers, 820136, yep. Okay. So I think of this as an A and a B style conveyance. It says, I give you easements as shown in the survey, and under, I'm going to call those the old auditor's file numbers, and under those old auditor's file numbers. And this is relevant because defendant is going to harp on those old conveyances and prior access to the road. We're not here arguing about those old auditor's file numbers, and they're irrelevant to understanding whether or not there is an easement as shown in the survey. Okay, so this is the beginning of the chain of title of defendant's property. It was sold together with, subject to, those easements of record. Going to the very next exhibit, Exhibit E to plaintiff's declarations, just a page down. It's a real estate contract, and the real estate contract was 2002, and it's conveying out from Chilton's, that common owner, to the first purchaser. And if we go to the last page of that, we can see some similar language. It conveys out tract 1 of survey, gives us that auditor's file number, so we know we're looking at the correct document. And what's it say? It says, together with an easement for ingress, egress, utilities, as shown in the survey. And then again, it references that survey yet again. And as provided in documents recorded under those old auditor's file numbers. It has an A and a B style easement conveyance. And in my analogy of A and B, A is the new and B is the old. All right, we're only worried about A today for this hearing. And so we're left looking at the May 22nd, 2001 survey. The issues leading up to this are just a bunch of confusion of how to read this survey. Defendant would like to use surveys that are completely irrelevant to say, hey, I don't see an easement over here, but those surveys aren't what establish any sort of conveyance. A conveyance is going to be by deed. Deeds include legal descriptions. Legal descriptions can be found in surveys. There is not ambiguity in that. This idea that there is strict necessity or really any necessity for an easement to be valid is not supported by Washington law. Imagine you're leaving your neighborhood to go to the store. Somebody stops and says, you really need to go to the store? Can't you do 1 trip instead of 3 trips this week? That's not how easements work. There is no authority supporting this idea of limited access. Plaintiffs would like to use this easement for ingress and egress, not go into the store. They want to go to the property west of defendant's property, Pacific Corp property, and then there's a lake even past that. Whether or not they have some valid easement past defendant's property is not before the court. It's not relevant to answering the question of whether or not plaintiffs can ingress and egress. Defendant cites authority talking about when there's ambiguity, you can bring in extrinsic evidence. You, of course, need ambiguity in the first place. One, there isn't, because we have a clear conveyance of an interest in real estate here.
Counsel, let's go back to the maps for a minute. So I read at length in detail these declarations, and I want to turn to the original declaration of Dan Renton. Specifically, his expert report, I'm using that term loosely. I recognize him. I don't think anybody's certified anybody is an expert on this yet, but
Okay.
let's turn to paragraph 5.
Okay.
He says this easement, you're talking about the easements that you've been referencing as well. This easement, I'm reading from paragraph 5, this easement gets you from the end of the county road to the 40-foot easement that is shown on volume 22 of surveys, page 105. That is, it does not give you a right to continue into the Richardson property. The Richardson legal description uses the same easement language as the ORA legal description. If you look at the survey recorded on volume 22 of surveys, page 105, the 60-foot easement does not continue through the Richardson property. So where do you have, in your client's perspective, unambiguous documents showing that those easements do continue through the Richardson property? I want to ensure that I'm looking at the right map where you believe that statement by Mr. Renton is incorrect.
Well, again, Judge or Commissioner, that starts with this assumption that necessity exists, that you need to have some access to some greater place other than just um, a recreational Pacific property, right? So his whole assumption behind that is incorrect. But
Well, isn't that a dispute of fact then that I should deny summary judgment on?
no, no,
Why?
because that starting point of saying, well, you don't have um, a need to go beyond the end of the easement, that isn't the question of whether or not there is a valid easement. So we're not asking, can the ORIs travel past the easement? We're not asking, do they have some other easement? We're asking, can they ingress and egress over what's shown as the 60-foot easement on the Richardson property? If the next landowner wants to bring a claim, okay, we'll address that in a separate lawsuit. But Miss Richardson doesn't, represent or hold the interest of some further property owner. My client's goal out of this lawsuit is to ingress and egress over their easement.
I get that. So what map do you, so again, I have a fact opinion, and I'm not going to get into whether or not it's an expert opinion, but I've got facts in evidence and a material summary judgment that seem to be in direct dispute for the purposes of summary judgment, what your clients are defining the ingress and egress is. Isn't this a fact question for a trier of fact? Why would I determine this on summary judgment?
Because there's no authority saying that the absence of necessity it leads to any sort of invalidity of an easement. So, for example,
I'm not tracking that, counsel.
okay, let's say hypothetically, my clients are swimming at the lake, and they walk through the Pacific property and they get to the easement. Wouldn't they have the right, and necessity is very subjective, right? But at that point, they surely would have the need to travel across the easement. And is the easement less than valid at that point? And vice versa. If they're standing at their property, they want to travel west of the Richardson property. Just because there's some other access point to some other road to the east doesn't mean the easement to the west is invalid. And opposing counsel hasn't pointed out any authority stating otherwise.
I'm not questioning my issue is not the legal basis for which these easements exist or were created or don't exist. My question is, isn't there a question of fact between what your clients are asserting and what this evidence is asserting under paragraph 5? They say paragraph 5 says the easements don't exist. Your clients say the easements do exist over the parcel. They say they don't exist over the parcel, over the Richardson parcel. Isn't that a dispute of fact to be determined at trial?
It's an assertion, and it's a conclusory assertion without authority or explanation behind it that would carry weight. Mr. Renton here is signing declarations that just give a kind of a bold-faced assertion of a conclusion of law, and he's not a judge, he's not even an attorney. And so where's the authority saying, here's the facts I allege, here's the authority, we put A and B together and we get this outcome. That's what defendant hasn't provided for you. Defendant would like you to say, well, because you can get from your house, you're sitting on your couch and you want to go somewhere, because you can go one way, everything else is invalid. That is contrary to the actual conveyance. Member conveyances are, in writing by deed, satisfy the statute of frauds, the real property conveyance that we see in front of us. In the entire deed history, we see it depicted and labeled in the 2001 survey. And so opposing counsel would have you throw all of that out for this idea that there's another way to get out of your house.
No, that's immaterial. It doesn't matter to me how they get in or out of their house. The question is, isn't there a dispute of fact about what these easements are and where they are? Because that's what I read in paragraph 5 of Mr. Renton's declaration. You're saying they go, you're saying based on your interpretation, which I didn't see you haven't, I guess, an expert surveyor's report by someone who's deceased, and I'm not sure what to do quite with that yet, but he says in paragraph 5, or rather, in paragraph 6, paragraph 5 and 6 together, these easements are contemplated and intentional, and they serve the ORI property for the purposes stated in the survey, which is, and that's paragraph number 7, ingress, egress, and utilities. And I have paragraph number 5 of Mr. Renton that says, no, that's not the case. For the purposes of summary judgment, aren't these two competing paragraphs? Paragraphs 5, 6, and 7 of the Blum Declaration, and paragraph 5 of the Renton Declaration. For the purposes of summary judgment, these seem to be facts that are in dispute. And I don't have a way on summary judgment. And in fact, it would be against Mr. Jackson, your client, because it's the non-moving party that gets the benefit here. Isn't there a dispute of fact?
Well, no, Commissioner. Okay, look at the last sentence of paragraph 5 of that Renton report.
Okay.
He says, if you look at this survey, the 60-foot easement does not even continue through to Richardson parcel. All right, that's exhibit G.
Yeah.
He's overlooking the fact that it absolutely does in the one and only survey referenced by the conveyances. Conveyances are, the interest in real property conveyed to the owners. And let me.
But counsel, you're saying it absolutely does, and he overlooks it. That is a dispute of fact. So anything I want to give anything else you want me to know, because I'm not seeing how we don't have a direct dispute of fact here. At least this is a 60-foot. We'll get to the 40-foot in a minute. But on the 60-foot, I'm just seeing, I don't know how to reconcile these two very opposed declarations of fact.
Well, Commissioner, if you close your eyes to the only survey that's referenced in the deeds, then yeah, his position makes sense. But Mr. Renton can't bury his head in the sand and say, oh, I'm seeing I'm not seeing something.
But that's a question of credibility that you would have a chance to rebut or cross-examine on at trial, right? How can I weigh credibility on this issue at this stage of the proceedings?
Well, you don't need to, because he doesn't claim that this 2001 survey doesn't show, what he's claiming is a different document doesn't show the easement, right? And so, oh, okay, that's fine. Maybe a different document doesn't show what we're looking for, but how is that relevant to whether or not the correct document shows what we're looking for?
So again, let me turn then to paragraph 4 of the Renton Declaration, the supplemental declaration of Renton. Paragraph number 4, the plaintiff states the 60-foot easement was created in 2001. That is incorrect. As stated paragraph 3 of my report, and further, the access easement was created in 1979. The 60-foot wide easement was for the access to County Road and did not cross over what is now the Richardson parcel. Again, I've got two. You may well, I have no idea. You may prevail at trial. All I am suggesting is, how do I reconcile these facts of dispute for the purposes of summary judgment at this stage?
Well, it's not a genuine dispute when Mr. Renton's declaration makes it clear he's not reading what's actually conveyed. Remember that A and B style easement conveyance? He's looking at one and not the other. And he's right. If you only look at one and not the other, then you would reach that conclusion. But again, it's an A and a B style conveyance.
Response, Mr. I want to, let's take response, Mr. Conway.
Yeah, yes, Your Honor. There's a lot here to unpack. I can jump into that. I think our argument was misstated, but I think at the end of the day, our main position is going to be there's an issue of fact. In that, I don't think the court can weigh competing expert opinions at the summary judgment stage. So I can go into further detail on all of that. I don't know how much I want to leave time to get to the 40-foot as well. But essentially, I'll just give the brief points, I guess, Your Honor.
Sure.
If we look at Mr. Renton's declaration or report, he goes into the history of this 60-foot easement, and it was clearly over Ham Road to access these 3 parcels.
Hmm.
What happened was, and that's in the chain and in the title, what happened was when Mr. Bloom went to do the boundary line adjustment, he made a mistake in that he put the 60-foot access easement, but he continued drawing it because the road kept going down to the Richardson property. And so he drew that on his survey, which was, didn't show up on later surveys. Mr. Brown didn't include it. And you have Mr. Renton says that it's not up to professional standards because it's nowhere is that portion on the Richardson property ever identified like the rest of it. There's no legal descriptions. We don't know where that is. We're assuming it's her driveway. And so then you get to just the kind of the common sense type viewpoint is that he obviously just drew the driveway because the driveway ends at the house. The survey shows it kind of touching the property to the west, but it doesn't. And so what they're really asking for is not any sort of access, ingress or egress to their house or utilities to their house, because that's impossible. You can't access their house from that. They already have access through the correct portion of the 60-foot easement. And so you have these neighbors, and we've gotten into the history, and I won't go into it now. Mrs. Richardson saying Mr. Lorry's shining lights down on him and put up signs and dead baby deers and cut down her trees and this sort of thing. And so what they're asking to do as part of this is to walk down her driveway, get off her driveway, cross her woods, and go access the reservoir. And this goes right by her house, right by her bedroom. And that's clearly not, I mean, it's a bizarre request. It doesn't get past the issue of, okay, well, she'll just fence her property and there won't be any access to the lake. So if we look at the chain of title, if we look at all the pre-documents, the 60-foot easement was in existence already. And what Mr. Renton is saying is, hey, you can't create this easement by just drawing it on a survey and not even giving any sort of descriptions or anything on it. So that's kind of the long and the short of it. But I think we get down to if we have Mr. Bloom's declaration, which kind of speaks to counsel's point. It just says, hey, this is my survey, and he mentioned some hearsay about Chilton's intention, but you have that declaration, which we're not able to contest at all because he passed away, unfortunately. And then you have Mr. Ritten's report and two declarations. He creates the issue of fact there. So I don't think it's appropriate to grant any sort of summary judgment at this stage, Your Honor.
Thank you. Mr. Jackson, any further response, at least with respect to the 60-foot easement issue?
Briefly, opposing counsel says you can't create easements by drawing them on a survey. Well, actually, that's the only way these easements were created. The 40-foot easement that's not being contested, Miss Richardson's own access to her property is shown via 60-foot easement drawn on a survey. And so by opposing counsel's logic, Miss Richardson can't drive to her property. That's all that relates to the 60-foot easement.
Okay, let's turn our attention to the 40-foot easement. Counsel, what's your, I think, as I interpret your pleadings, we agree, or you will both agree that there is a 40-foot easement of some form or fashion. Is that accurate? I'll turn first to Mr. Conway because I want to make sure I understand what, if anything, Ms. Richardson is agreeing to.
Yes, Your Honor.
Or not contesting, perhaps.
Yeah, we're not at this juncture contesting the existence of the 40-foot easement, and that's clear because that easement is legally described. It's in the deed history. It's not merely doodled on a map. It's an easement. What we're contesting, and I can dive into or let counsel go first, however the court wants to handle it, is there's this permanent injunction that's being asked for, and it's presented in the motion in the declaration that this is needed to access this shop, and Mrs. Richardson, blocked it through all this. But we've learned from Mr. Ori's deposition that the only possible thing that he testified was in the way of this easement is a pole that he said he could drive around, which my client will probably remove anyways. She just hasn't gotten to it after the depot. So there's a pole there. Our main concern is that there was a survey done which shows us the location of this. Mr. Ori went and took all the stakes out. So the surveyor wants $2,000 to go back out there and put it. And so the issue is he put a retaining wall, fire pit, all these things. And so what he's done is torn down Richardson's area, is trying to build a road there. Meanwhile, has blocked her easement on his property with all these retaining walls. So it's a big factual quagmire if we want to wade in there, but I think the overarching is we're not contesting that. We believe both parties should have rights to use that area, and then the portion that's not being used as a roadway, the parties would have a right. That's still their property, and there's case laws on what you can do on your own property that has an easement on it. So we're still asking that we be allowed to use that property as it were our own if it doesn't impede anybody's ingress and egress.
Response, Mr. Jackson?
Yes. So first, the second declaration of David Ori filed March 4th shows through nice pictures a very different story. To say that there's just a pole out there and that's it, that's not an accurate statement that the pictures will show. Perhaps today, because of legal intervention, Miss Richardson is taken action to clean up some of her mess. Perhaps today it's different, but only because of my clients having to hire an attorney and take legal action has there been significant change. That declaration really says it all. 2024, 2025. There's these huge banner style posts. And it's hard to understand the scale of this until you see the second picture. See a defendant's boyfriend standing way up high in a bucket of a tractor. These is a really big tarp banner style fence and signs. And then they've stored miscellaneous stuff there on the easement. They've used their tractor to dig a hole there over an alleged drain field that doesn't exist. they've placed broken appliances. They've written messages on the appliances. I think there's a toilet out there. Those are well shown in that declaration. In response, Miss Richardson doesn't say, "Well, none of that ever happened." And how could she, looking at these pictures? She just says, "Well, I'd like to use my portions of the easement too," and that's fine. My clients aren't blocking her from using portions of an easement. My clients for a few years have faced blocking of the easement, and they would like to be able to use it.
So is there any blockage now?
I believe most of the garbage was cleaned up within the week, and
Okay.
so um, if you there would be minimal today, but again, only because of this lawsuit.
Well, but again, I recognize that may be a question out of this lawsuit, but it is not a question in this motion. Does that make sense? In other
Uh,
words, for the purposes of summary judgment, the only question is there a 40-foot easement that exists or not? And I hear Mr. Conway to say, yes, there is, and in agreement with your motion for summary judgment.
yeah.
Now, whether or not that easement is overburdened, whether or not it is being intentionally or unintentionally interfered with are all separate issues that I don't think are before the court today in the form of this motion. Does that make sense, Mr. Jackson?
Yes, I understand. Are we on the same? We're not disputing their use of my client's side of the easement. So when I hear overburdening, I think that.
Well, I mean, whatever is going on, I don't know, retaining walls or trash blocking it.
Yeah.
What I hear is Mr. Conway agrees that, or his client, not himself, but on behalf of his client, agrees that there is a 40-foot easement for ingress and egress.
Yep.
Now, whether or not that is being intentionally interfered with is not before this court at the current juncture. The question of the motion for summary judgment that was cited in was, does a 40-foot easement exist or not? And as I hear today, the answer is yes, everybody agrees that it exists and that it can be used. Whether or not it can actually be used is a separate proceeding and a separate question. And there may be some dispute as to the location of that 40-foot easement. Do I have that right, Mr. Conway?
Yes, Your Honor.
So, Mr. Jackson, I think here's where I think I'm at on this. And I've read everything. I think I read it when it came in December. I've read everything again, both the December materials and the materials that came in within the last few days. I've read it, I think, most of it now twice. There is in my view, a clear dispute of fact precluding summary judgment about the 60-foot easement. So I'm going to deny summary judgment on that issue. I will grant summary judgment as it were with respect to the 40-foot easement, because as I reviewed the pleadings, at the initial time, there was a dispute about the existence of a 40-foot easement. Now the 40-foot easement is agreed that it is now in existence.
Okay.
I'm going to reserve on issues of attorney's fees. I'm going to reserve on any issues of damages. I'm not going to wade into that right now.
And Commissioner, I believe the injunctive relief was part of our motion. I'm confused as to why that's not.
Well, where in your motion, in your memorandum in support is it?
Okay, well, so there's a motion. It mentions injunctive relief. My memorandum.
I see it.
Yeah.
I'll reach that in a second.
Okay, understood. And perhaps it would make sense to that wouldn't be granted for the 60-foot easement, of course, under the circumstances.
Well, so Mr. Conway, do you have any evidence because as I read it, your client is effectively admitting at least some of the conduct and has now cleaned it out. Is your client put any specific record evidence in related to blockage or disputing blockage of the 40-foot easement?
Yes, Your Honor. So there's
Where
kind
is
of
that?
just fairly quickly, if I may kind of outline this. The pleadings were filed, and they essentially led that she had blocked it with a gate and a fence and these tarps and things. So the testimony, the pictures, and the deposition of Mr. Ori, there was never any fence, and the gate was across the 60-foot, not the 40. He testified to these tarps, which were placed to block a spotlight he had shining into my client's windows. Those were removed when the light was removed before this lawsuit even began. And there were some other items there that were removed before the lawsuit even began. There were items such as trash that were outside of the easement area that were removed. And then the only thing he testified to in his deposition that I took prior to this, and I attached the testimony, was there's this pole that the tarps used to hang on that may have been in the easement area, but it wasn't really blocking his usage. So I would just point to his own deposition. I know he may have changed that testimony kind of throughout and kind of try to polish it up with his declaration, but his testimony when taken that there's none of this there. There was some garbage. My client couldn't remove it because there was a restraining order against her, not allowing her on that. That has since been cleaned up. So we're not aware of anything other than this post, which again is not really, I don't even think it's in his 20-foot side where he's building it, but that's the only thing I'm aware of that is anywhere near this easement.
Okay, Mr. Jackson, your response on that issue?
The pictures speak for themselves. That second declaration of David Ori, sure, today it might be cleaned up a bunch. The pictures show a barricade style fence. Sure, it's not like a field fence like you expect when you hear the word fence, but it's certainly a fence of sorts. My clients have been plagued with these issues for the last couple of years. Just because the defendant cleans up her act as there's legal intervention, doesn't mean that my clients are not entitled to a permanent injunction.
So my thought, Mr. Conway, is to issue a permanent injunction, at least with respect to the 40-foot easement. I'm not, again, my ruling precludes that on the 60-foot.
Which I think is fine, Your Honor, but there's we need to know where that easement is.
Well, and that's the real question that I'm coming to.
And we had it surveyed, and Mr. Horry ripped up the stakes, and now they want another $2,000 to redo it. And so I think why he doesn't want to do it respectfully is that a lot of his developments are outside the easement or on our side, and we don't have to solve that today. I hope we can work together and resolve that moving forward. But I would just like a clear idea of where that easement is so both parties can not interfere with it. I think it should be a two-way order. I'm sure the court's aware, reading through the materials, of all the back and forth between these parties, and we would like something that would help resolve this.
Mr. Jackson, how do you, with respect to the 40-foot, how do you want to resolve this question about where it actually is located?
Well, I object to those accusations of Mr. Ori.
Well, I'm not questioning whether or not he did it. I'm just saying if there's a question as to where the easement is located, how do you want to deal with that, sir?
Well, I guess it would need to be marked, and rather than the center line marked, the problem with marking the center line is inherently down the middle of this easement. It would make sense to mark the perimeters of the easement rather than the center line. I imagine any of these surveyors that have been out there recently would be able to do this in an economical way.
Give me just a second. I need to talk to my judicial assistant because the hour is getting late.
What do you think, Helen?
For this?
Total, yeah.
Oh, I'm going to try to get out of here at 5.
Okay, cool.
Yeah, okay.
Thank
Thank you. Okay, so yeah, we need to wrap this up because I got one more status conference that I need to have here. So here's what we're going to do. I am inclined to grant a permanent injunction over the 40-foot easement. I think there's practical considerations that are difficult there.
Well,
But hang on.
mm,
What I want to do is set this on in 2 weeks for entry of orders. I would hope that the two of you, now that you've heard my rulings, again, I want to be clear. I'm granting based on what I perceive as an agreement that the 40 exists. The question is where, that I am going to find for the purposes of summary judgment that they had, the 40-foot is, I'm granting summary judgment on the 40-foot. I'm denying it because I think there's a factual dispute over whether or not the 60-foot exists. And then I am inclined to grant a permanent injunction on the 40-foot, but I'd like the two of you to confer before we do an entry of orders to figure out how we're going to deal with this question. I think it is not a good idea to have a lingering dispute about where it is located. I think that will be a recipe for disaster quickly in this case. Does that ruling, do either of you have concerns about that ruling or need further clarification?
no, and I think it's worth pointing out that I have a legal description for the 40-foot easement. Perhaps it was attached to my complaint.
Well, it may be. I just want you two to confer about that.
Yes.
But having a legal description is not the question. The question is, where does what mound of dirt does that legal description match to? I think that's the issue with the surveyor stakes. And I'm not saying your client did or didn't do it. I think it is a reasonable question. If there are not survey stakes for whatever reason, I don't know, the deer dug them up, who knows? If they're not out there, I think it is a reasonable question as to where exactly this 40-foot is, even if we all agree that it exists. Does that, Mr. Conway, does that create
Yes,
a
Your Honor.
clear ruling in your mind, or do you need additional information?
I understand, Your Honor. Very clear. Thank you.
So let's put it over 2 weeks for entry of orders, and go from there. That would be the 8th at 2 p.m. and we'll try to get you out of here quickly. Again, please try to confer. It's the form of the order. I'm not going to require that you do so, but I think in this particular case, the best way to get to the bottom of where this 40-foot is, if you cannot agree, then what I will probably do is invite additional briefing, and then I'll end up, after reviewing whatever facts are presented by both parties as to where the 40-foot should be and who should pay the cost of that, I'll have to make a decision. But I'd prefer if the two of you can work it out. But if not, the court stands ready to do so after briefing.
Thank you, Your Honor.
Thank you, Judge.
All right. Thank you both. Have a good day. So I had a chance to review the pleadings by both parties in the case. I want to be succinct. I appreciate you both being here so late in the day. I thought I was going to try to cut your time on the docket by having you at 4. I should have said 4:30. So thanks for bearing with me. So on the issue that is whether or not, as I understand it, the issue before the court today is whether or not to grant the a evidentiary hearing as to whether or not Mr. Winters should, whether or not the Mr. Winters should continue to be restrained in a permanent fashion from Ms. Shields. Is that right, counsel? Is there any other outstanding issues that we need to decide today?
No, that's the issue, Your Honor.
That's what I understand the issue is as well.
So I've reviewed the pleadings by both parties. I am inclined to grant it, but I'm sorry, it's a long day. The attorney for Ms. Shields, counsel, Mr. Gade, if you want to make your argument for the record on why it should not be granted, I'll certainly entertain that, but I will tell you both that I'm inclined to grant the hearing.
Sure, Your Honor. We had the hearing. You heard all the testimony. You realigned the parties. You found that Mr. Winter was the one harassing my client. And I think at the end of the hearing, you said we need to come back and just decide if it's going to be, a 1-year order or a permanent order. So it seems kind of duplicative to have a whole nother hearing And you can hear about all the same things again about how he went off and blew the sale of my client's house. So it's going to be redundant, but if, it seems unnecessary. It seems like we had the hearing, you made your ruling, so we just need to find out how long the order is going to be for. That's our position.
Well, I think there might be well, Ms. Denver, go ahead and make your argument.
Thank you, Your Honor. We obviously believe that a contested hearing is required. At the prior hearing, my client appeared as a petitioner presenting evidence in support of his claims. After the court realigned the parties, a new petition was filed. It was about 97 pages long against him. That places him in a fundamentally different posture as the respondent defending against allegations. And I believe defending against a petition involves a different presentation of evidence, different witnesses, and different cross-examination. That has not yet occurred. And I would note that this, Your Honor, at the contested hearing, or at the prior hearing, the court stated that the order would be temporary and that there would be an evidentiary hearing. And
I recall stating that.
okay. And I believe the statute indicates that posture as well. It says the court may realign the parties, enter a temporary order, and allow the newly designated petitioner to follow a petition. I believe once that petition is filed, it should proceed under the ordinary protection procedures, which include a hearing. So for those reasons, we're requesting a contested hearing, which should ensure, my client a right to present evidence and witnesses and defend against the allegations that are now before the court.
Your Honor, so here I'm Your Honor in this scenario. So counsel, both, it was argued very well, but Mr. Goody, I do think the proper process here in a due process issue, I do think it's fundamentally different to ask for a protection order as a pro se versus defending a protection or against a protection order. I recognize there may be overlapping testimony. I'm sure that you're highly capable to the extent that would be inconsistent testimony of impeaching accordingly. But I do think that the proper process and due process likely requires here, and the statutory schema likely requires here, a separate hearing on that full order. And so I do think it's appropriate to grant the evidentiary hearing. Now, that said, I do think I have authority under the statute as well as to put some limitations on live testimony versus testimony by declaration. So what I'd like to get a sense of from both of you, and I'll start first with Mr. Gooday, is do you intend to put on witnesses, and if so, how many? And how long do you think your presentation will take?
I guess it would just be my client, and we have declarations supporting everything else, so we could just go on the pleadings as well if the parties want to do that, but
Have witnesses.
Okay, and so you would anticipate, I would assume, for any examination and potential cross-examination, less than 15 minutes for your client, Mr. Gooday, is that right? I can't imagine it would take longer than that.
no, I mean, we're going to be submitting more declarations in response to the declarations
understand.
that, so
I'm
I'm
talking about
most-
live testimony.
yeah, live testimony. I don't plan on, 15 for my client and then maybe 15 for another witness in case we want to have a second witness,
Okay.
like my client's mom, maybe.
Ms. Denver, how long do you believe, and my thought is I may be willing to give you one additional live witness, but I think much of this can be done by declaration. And I think I have the authority to set limits on live testimony when it comes to protection order hearings. And so how many live witnesses do you anticipate?
I probably just anticipate my client and potentially one more. We have already filed some declarations, so we would ask the court to consider those and exhibits, but essentially, in terms of live testimony, it will probably be 2 people, my client and his wife.
And do you agree that your presentation can be accomplished in under 30 minutes as well?
I would do my very best. Yes,
The answer would be yes, counsel.
yes, I'll do my very best.
Okay. So my thought is to set this matter at 4 o'clock so that we can go over to closer to 5, but it need to be done at 5. We could set it at 3:45. Counsel, or I'm going to ask my clerk. I know we set a couple of earlier matters to 3:45 on the future dockets. When do we have a 3:45 available coming up?
We could do a Tuesday or Thursday. That'd be ideal for me.
Yeah, that's a can of worms because then I have to take it off the docket and get a special set. I can do that if I need to, but it's rough. So I'm looking for a Wednesday. That would be the preference, but if we need to, I'll look for a different day. We don't have anything set for the 15th late in the afternoon. Okay. I know you counsel, Mr. Gade, your preference is not a Wednesday, but are you available after 3:45 on April 15? Mr. Gade, I think you might be muted.
Sorry, yeah, and that's gonna be in person at the courthouse. We're not doing Zoom
Yeah,
for that?
we'll do it in person. It's going to be too difficult to do it on Zoom.
Okay. If it's gotta be a Wednesday, then yes, I can make that work.
Okay. Ms. Denver?
Yes, I can do that.
Okay, let's set it for 3:45 on the 15th. That way we've got time. That'll be in person. Again, my preference here, and I think I know I have authority under the statute to limit live testimony. So my preference would be to do this by declaration for the most part. Certainly understanding that the 2 principal parties are likely to submit live testimony, and there may be one additional witness necessitating live testimony for either party. I may voir dire that witness, or at least inquire of counsel, depending on who that witness is, whether or not actually live testimony is necessary, or if I'll just take it on a proffer from counsel at the time. But I don't have a problem if a second person wants to come. I'm not going to prejudge whether or not I'll actually hear from them in live. I may just take a proffer.
Understood.
Okay.
Okay. So for clarity, I am going to go ahead and issue, continue the no contact order that was previously issued to that next court date of, I think we said the 15th of April 15th. So I'm going to extend the current anti-harassment order to April 15th. I'm going to prepare that and sign it off docket, but it'll be signed before I leave today. Any questions about that?
No, Your Honor.
Oh, you're on.
All right. Thank you both. Have a good day. I appreciate you bearing with us.
Thank you.
Thank you.
Have a good day.